Good morning, Mr. Corman.
Good morning, Your Honor. Good morning. My name is William Corman, and I represent Darren Grant in this matter.
Could you start by addressing the mootness argument?
Absolutely. As this Court is aware, while this matter was pending at the appeals court, Mr. Grant was subsequently rearrested for a similar offense. At the time he was arrested, he was on probation out of the Norfolk County Superior Court. As a result of the probation surrender, Mr. Grant was incarcerated for a period of time and subsequently given house arrest once on the new offense. So he was incarcerated on the old offense on the probation violation. On the new offense, he was given house arrest. He subsequently served that time, was released, actually is present in court today, and when just before he was released, the district attorney's office filed yet another petition against him. While that petition was going on, we waived probable cause. He was seen by 2 qualified examiners, and subsequently they both came back with a finding that he was not sexually dangerous. The Court had since decided the Johnstone opinion in this case. I'm sorry, the Court had since decided the Johnstone opinion, and as a result, we filed a motion to dismiss, and that motion to dismiss was allowed by Judge Troy. As such, our argument is that there's really no present case or controversy before this Court. Essentially, the facts have changed to such an extent that the interim matter has overtaken this particular case, and that therefore the facts and circumstances beyond that other case have changed to the point where, quite frankly, they're no longer relevant.
And do you think the Commonwealth argues it's capable of repetition yet evading review? What's your response to that?
What I would suggest to the Court is that there are really 3 pathways to take a look at this particular case. There's the mootness issue. There's the micro issue, which is the findings of the judge in this particular case, and then there's the macro issue, which is sort of the overarching point of view in this particular case. I would suggest that the Commonwealth is right concerning issues surrounding a finding of dangerousness in the sexually dangerous person proceeding. I would suggest to the Court that in terms of Mr. Grant, the issue is moot. So I think it's a little bit of both. I think this Court can agree that as far as whatever decision this Court makes, it shouldn't apply to Mr. Grant since there's been a subsequent proceeding.
Mr. Corman, I'll ask Ms. Burbine, but, capable of repetition, do you know how many people who have committed nonviolent sexual acts? Here the underlying statute is shock and alarm. So do you know how many people have been classified as sexually dangerous persons?
Under just nonviolent, hands-off, sexually dangerous offenders. I don't have that statistic. What I can tell the Court is that, as you're well aware, these are highly factually specific cases. And sometimes it's not just an individual's criminal history that is involved, but also details they've revealed during therapy, non-charged events. So there's a whole host of issues that sort of filter on through what ultimately is a potential label of sexually dangerous. Regarding Justice Botsford's question, if the question is how do we take a look at this case from a macro point of view, which is the point that perhaps is capable of repetition yet evading review, then the answer and the underlying
Well, I'm not so sure it is evading review. I mean, I guess that's I would suggest that, it either is a non-issue because, as in your case, the person isn't found by 2 examiners to be sexually dangerous, or the person is, and you can review it. I mean, I'm just not sure that we should get to the macro in this case.
That's certainly a decision for this Court to make, but I would suggest that if the Court wanted to take the plunge into the macro issue in this case, it would be the issue of whether or not the Commonwealth needs to prove dangerousness in individuals.
Well, they clearly need to prove dangerousness. The question is, what does that mean?
Quite frankly, I agree with Your Honor. I think the Commonwealth disagrees. I think the Commonwealth says...
The Commonwealth says you don't have to prove physical dangerousness, but dangerousness like injury can include emotional and other kinds of...
And that's certainly what the McCool case states. Again, pointing to this specific case, Commonwealth versus Darren Grant, there was no testimony as to what the potential injury was. As a matter of fact, the judge addresses that in his findings, where he says that the individuals who testified on behalf of the Commonwealth, Dr. Feldman and Dr. Murphy, were unable to testify as to what potential harm this had on the victims itself. And that's where the judge goes on to say that the conduct is certainly illegal. I think the word he uses is disgusting. But when an individual is subsequently sanctioned, in this particular case, there is no evidence as to what effect it had on the intended victims, if you will.
Well, if you use the, I take it the Commonwealth's case, and going to the macro. I mean, if you say that somebody is a sexually dangerous person because of a personality disorder, where do you get into dangerousness?
Well, again, it's interesting to note, and I think the judge mentions this in his opinion, that there seems to be a disconnect where if a person has been convicted of an enumerated offense, if a person is diagnosed with a personality disorder, and experts testify that person is likely to commit that offense again, as likely has been defined by this court, that person is a sexually dangerous person. It's when we deal with the issue of mental abnormality that there's sort of a balancing test that comes about.
But you don't need that, do you?
I'm sorry, Your Honor.
I mean, it's an or in the statute, right? I mean, just looking at the statute, you could avoid mental abnormality completely, couldn't you?
Well, an expert is going to diagnose an individual with perhaps a personality disorder, perhaps a mental abnormality, or perhaps neither of the above. I think there's, as I said, a disconnect. These are legal, these terms as put in the statute are legal terms. There's also the psychological terms. There is a difference between a personality disorder and a mental abnormality in terms of the psychological makeup of what one is versus the other. And I'm certainly not a psychologist and not going to delve into the difference between the two. But the statute seems to create a difference between the two.
Right.
And I would suggest, as I set forth in the brief, that in and of itself, I suggest, poses some problems. There almost is a bit of an equal protection issue here because, one, under personality disorder, enumerated offense, likely to commit future offense, sexually dangerous person. Mental abnormality, enumerated offense, mental abnormality, well, now we need to delve into this whole what does it mean to a degree and menace, so on and so forth. So I think the statute in and of itself creates some problems. And while Your Honor may be hesitant to delve into that, at some point it's going to have to be addressed. It may not be this particular case, but there are a number of issues which I would suggest this Court can use the Darren Grant case to resolve. One is there an equal protection problem between individuals who are diagnosed with a personality disorder and mental abnormality? And another is, what does the to a degree mean in the terms of mental abnormality? The Court took advantage of the term likely, or I should say the Court defined the term likely in the Boucher case, and I would suggest that similarly the to a degree phraseology is also as ambiguous as the word likely is. Obviously, if we take a look at what to a degree means, the common definition has to do with scale and scope, and in and of itself, it creates a measurement. The term to a degree requires somebody to do some sort of balancing test. I think that the definition of the definition of to a degree really means to an extent that, or on a scale greater than.
Could I ask you this?
Sure.
The judge says, I don't really have to get into whether it's personality disorder or mental abnormality because, after all, Addington versus Texas says you need to have dangerousness. That really isn't what Addington's about. Wouldn't you agree?
I would suggest to the Court that while we agree that the ultimate result of the judge's opinion is correct, the formulation that the judge used to reach that result probably could have been phrased a little better.
Go ahead.
Excuse me, go ahead.
Well, so to get to your point, which I take it is your point, that whether it's Addington or something else, you do need, I take it constitutionally, you would say you need some kind of dangerousness.
Absolutely.
So what is it that's not out of Hendricks, is it, or is it? Where are you getting that?
I would suggest that it's partially based in Hendricks. I would say the Court can also find language in the Boucher opinion, where we discuss exactly what needs to happen. That it's a factor determinative test, and this Court, the finder of fact needs to balance certain issues and certain factors, and going through that, they would reach a result of perhaps dangerousness or perhaps not. And it doesn't make any difference, quite frankly, whether or not we're defining the term likely or we're defining the term to a degree.
Well, isn't it fair to say that, to a certain extent, the legislature has concluded that someone who is likely to commit certain offenses is dangerous to the public health and safety? Isn't that a legislative conclusion that you're essentially asking us to set aside?
Well, I disagree with that, Your Honor. I would suggest that the legislature requires certain steps and requires that certain findings be made, that there's an enumerated offense, that there's the existence of either a personality disorder or mental abnormality, and that the individual be likely to commit future offenses. I think it...
Not just any offenses, future offenses listed in this statute.
Well, future sexual offenses.
Right, listed in the statute.
Correct.
Am I wrong about that?
No, I don't believe you are, Your Honor. But I think that this Court's decision in Johnstone is also instructive. The qualified examiners that are set forth in the statutory scheme by the legislature, I think Johnstone acknowledges that these qualified examiners have a unique role. These individuals aren't simply to testify before the court. It's sort of a checklist, the way I would suggest the appeals court would like to have happen in this case. I would suggest that the qualified examiners have a specific role, and they're to interpret. These are issues that are beyond the findings of most average individuals, and the qualified examiners have a role, and that's to interpret specifically what they've learned and what they've gleaned. And they're the ones who have to determine whether or not it's to a degree. They're the ones who have to determine what is reasonably likely to occur. And it's in that context that I think this Court can also take the Johnstone case and bring it to the next level. If the qualified examiners
I thought you were suggesting in your brief that it's really up to the jury to determine whether someone is likely to commit offenses to a degree that they pose a danger to the public.
What I'm suggesting is that the fact finder ultimately has to make that decision. But the appeals court decision in this case basically says that the qualified examiners and the respondents' experts got it wrong because they misapplied the law. What I'm suggesting is that as per Johnstone, the qualified examiners in theory have nothing to do with the law. The qualified examiners are expert witnesses with a particular skill set, and that they've reviewed, in many of these cases, hundreds of these individuals and have reviewed hundreds of these reports. And therefore, when they go through these reports, they can't simply go by a checklist that the appeals court would suggest is necessary in this particular case.
Well, they make a determination, a judgment as to whether or not the person is suffering from a mental abnormality or a personality disorder.
Correct.
And whether that would make them likely to engage in additional offenses. Those are two judgments that they make.
Or the to a degree, if there's a situation that evolves out of a mental abnormality as per the definition provided in the statute.
Okay. And you say the appeals court has rejected that.
I think that one of the concerns about the appeals court in this particular case is they've almost created a per se category of sexually dangerous persons. Individuals such as the respondent in this particular matter who are afflicted with exhibitionism will most likely, according to the respondent's own experts in this case, they will most likely offend again. And what essentially would happen, therefore, as per the appeals court, is there's a checklist. Number one, convicted of an enumerated offense. Yes. Number two, afflicted with a mental abnormality. Yes. Number three, likely to offend again. Yes. Well, that can't be
What's wrong with that?
That can't be what the legislature intended.
What they said, though.
But they also included the words to a degree. So the appeals.
Well, that's within the definition of a personality disorder.
But I think that it's difficult to determine whether or not somebody has well, it's actually in the definition of the term mental abnormality.
Mental abnormality.
But I think it's difficult for an expert to apply the terms without knowing the definitions of the terms that they need to apply.
Well, of course it's difficult, but that's what they do, and that's what they do in the regular civil proceedings when there has to be a determination beyond a reasonable doubt that a person is mentally ill and constitutes a danger to themselves or others. I mean, what does that mean? They have figured it out.
And that's why I'm suggesting the appeals court decision is wrong, because what the appeals court says is these experts are missing the point. And again, I don't agree with the appeals court decision clearly. What the appeals court decision seems to say is these experts are missing the point. The experts simply need to decide whether or not he's been convicted of a prior offense, if he's afflicted with a mental abnormality, and whether or not he's likely to commit the offense again. That's what the appeals court decision seems to say. But the fact remains is using the definition, utilizing the definition provided by the legislature, it's more than that, which is why I'm suggesting the appeals court definition is wrong, because the experts have to — I'm sorry, Your Honor.
So what you're saying is there needs to be an additional finding, other than this, in addition to this checklist, of danger, some form of danger, not just likely to engage in sexual offenses that the legislature has enumerated, but some sort of danger.
I don't know that it needs to be a new factor unto itself, or it needs to be a correct application of the definition of mental abnormality as provided by the legislature.
Well, if the legislature says these sexual offenses, these are offenses, not only sexual offenses, but they are the basis for commitment, isn't that a finding essentially that these pose a danger to the public health and safety?
They could find a danger to the health and safety. Again, and this goes back to what Chief Justice Marshall asked in the very outset here, I'm not suggesting here that every single individual who's similarly situated, every single exhibitionist or hands-off nonviolent offender could never be found sexually dangerous, as the appeals court seems to state. The purpose of these experts is there's escalations of patterns, there's a whole slew of conduct, and in the supplemental record appendix that we filed, the experts, the new qualified examiners, they go into it in great detail. They discuss why the offenses that have been committed by Mr. Grant and why his psychological makeup, despite the fact that he seems unable to stop doing this, why he's still not a sexually dangerous person.
But, Mr. Corman, there were qualified examiners in the case, not the new one, but this one, who found that he met the definition of mental abnormality, right?
Correct.
Was a menace to the health and safety of others.
Correct.
So I'm not sure what your argument is.
Well, in that case, in this case, it's the judge decided that he did not find those experts credible. He found that the experts who said he was not a menace to be more credible, and subsequently wrote a decision saying that Mr. Grant is not a sexually dangerous person.
In the greater scheme of things, as a person of the greater scheme of psychological illnesses, the hierarchy of psychological illnesses, are personality disorders considered more serious than mental abnormalities?
I don't believe that there's ever been any testimony by any expert that I'm aware of that suggests that. And I think that's where I said before, there's a disconnect, and that's where it may get into an equal protection issue.
Thank you, Mr. Corman.
Thank you very much.
Ms. Burbine?
May it please the Court, Carolyn Burbine for the Commonwealth. It's our position that the judge made an error of law here by adding an element.
Can you just start off by addressing the mootness? And let me just,
yes.
let me just explain what
Yes.
the issue is here. As I understand Mr. Corman's argument, it is different from the CPCS argument. So I'm just going on his argument, not on Amicus's argument. And he has just said he is not suggesting that nonviolent offenders, i.e., somebody who exposes, causes shock and alarm, could never be found not to be dangerous. Okay? So let's assume I agree with him. Why have I any basis to determine that this is not capable of repetition? In other words, it is a very, very fact-specific determination. And here we have, I take it, intervening facts that make, it seems to me, this individual's case moot. And you seem to concede that.
Well, I don't think it's moot where...
no, I thought you said it is moot. Maybe I'm wrong.
Well, I believe I said where the issue was, where the case was, the second case was dismissed. It wasn't fully litigated on the merits, but if the court did find that it was moot.
No, I understand. So let's assume that it's moot.
If we assume it's moot, I think it's capable of repetition, yet evading review, because...
I wasn't quite clear why.
These experts... these experts testify often, and these particular experts here...
There's nothing in the record that suggests that, is there?
I'm sorry. No, I'm sorry. It isn't, but I think that...
Let me tell you my problem. Generally speaking, I mean, it has to be so clear that it's not factually determined. Generally speaking, when we say it's capable of repetition and evading review, means usually a combination of two things. One is there's something about the nature of the claim that says in every single case, just given the amount of time that it takes to litigate, there's no way we're ever going to reach it. That's not this case. I mean, we happen to have somebody who reoffended, but there are lots of people who don't reoffend. So, and then, so the evading piece doesn't seem to be there. Capable of repetition, you may have experts who testify, but it strikes me that they may testify differently in another case. In fact, I think this is an area where sometimes the Commonwealth's experts are testifying for defendants and vice versa.
But if there's a misunderstanding, a general misunderstanding as to what's required by this statute, if there's...
Did you say there isn't?
I say there isn't. I say it's very clear.
And the appeals court has agreed with you.
That's true, but if judges are going to be confused over that issue, I think it's still something that should be resolved by the court.
Explain how you would resolve it.
Excuse me?
Explain how you would resolve it
By,
specifically.
by affirming the appeals court decision, which stated that it does not require infliction of serious physical injury on others if not confined, that that's not what the statute says, and that's not required.
Can
by
I,
the
can I
statute.
just ask you with respect to that, does that mean that going in the offense doesn't require serious infliction, or does it mean that there's a prediction that this person will inflict serious emotional damage?
I read the statute as saying that it does not require serious physical injury, and as the appeals court said, by the defendant's position, no one who is has been convicted of open, gross, lewd, and lascivious behavior could ever be found SDP because of this requirement of serious physical injury.
Well, the judge, didn't the judge just say that underneath it all, there's a dangerousness requirement? I mean,
He
that-
did. What happened was he never made any determination whether there was a personality disorder or a mental abnormality. Instead, he
Right.
said, "I don't have to get there because
Right.
Addington v. Texas says you can't civilly commit someone without finding dangerous to the public."
Right. So where's this thing that you need physical injury?
I don't see it here, but
So why, I mean, when the
But
appeals court...
if judges are going to be hesitant to civilly commit someone as a sexually dangerous person where they have non-contact offenses because they're looking for some kind of physical danger to the public, I think that should be addressed by the court as
Yes,
saying
but-
that's not
But if
appropriate.
the trial judge didn't address it, why should we?
Well, he did. He
just says dangerousness.
but later on he says it's curious that
Well, it's
personality disorder does not include a requirement of a finding of a menace to the health and safety of others, while the other one does. And so he ultimately said, where this is a non-contact offense, I can't find him sexually dangerous.
Now, what do we do with Hendricks and Kansas versus Crane, both of which the U.S. Supreme Court says we have consistently upheld such involuntary commitment statutes when the confinement takes place pursuant to proper procedures and evidentiary standards. There is a finding of dangerousness, either to oneself or to others, and proof of dangerousness is coupled with the proof of some additional factor, such as mental illness or mental abnormality. Why does that not say that the U.S. Supreme Court says that dangerousness is a required element of any civil commitment based on sexual offenses?
Well, I would say by the legislature putting on the list of enumerated offenses, open, gross, lewd, and lascivious, that is a finding that the legislature views this crime as posing a danger.
But that's,
And
then
I
that doesn't that mean that if it would then be your position, I take it, and it might not be an unreasonable position, the open and gross you have to shock or alarm, correct?
Mm-hmm.
So you've got 6 shock or alarms, right? You've got 1 conviction, 2 because a fact finder has found there was shock or alarm, right? No finding of dangerousness. And it's your position that you have to have some, that you, because the legislature has said if you do that, you're dangerous, that you therefore don't have a fact finder saying this person is dangerous to himself or others?
The way the statute is laid out is you have to be convicted of the enumerated offense, you have to have the personality disorder or the mental abnormality that makes you likely to engage in sexual offenses if not confined to a secure facility. They look at the likelihood so the danger the legislature was concerned with was the danger of reoffense. But they also, as part of putting this on the enumerated offenses, is a recognition that someone who exposes himself to adolescent girls, masturbates in front of them, does pose a danger to them. It's a crime that involves shock and alarm. There's psychological, mental, emotional trauma associated with it.
But how do we
physical.
know that there's psychological, emotional trauma associated with it?
Because in order to convict someone, they have to have testified shocked or alarmed.
Yeah, but shock and alarm is not harm. I'm shocked.
It's emotional. It's
No, I'm
emotional
shocked.
harm.
I was alarmed.
I don't believe it should be limited to that. It's not.
So are you saying that it's the legislative fact-finding is sufficient? We don't need individualized fact-finding?
No, I'm not saying that. But when you look at whether someone's likely to engage in a sexual offense if not confined, that's on a case-by-case basis. They look at the seriousness of the threatened harm, the relative certainty of harm, the possibility of successful intervention.
I understand that, but
But there's nothing that says it's limited to physical harm. So,
we're
and
not
the
talking
McCool
about
case
physical-
says that.
We're not talking about physical harm. We're talking about dangerousness.
Right, but dangerousness in terms of danger to the public by virtue of recidivism. And Kansas v. Hendricks, it was a sexually violent predator act that they were looking at. And it talked about, of course, because it's predatory sexual violence, they mentioned that it contained that element, but it never says that you cannot civilly commit someone for a non-contact offense.
Ms. Burbine, what are the
I
cases?
disagree that stands for that.
What are the cases to which you can point me where somebody was incarcerated under the statute or like statute where the dangerousness had not involved physical dangerousness?
I relied on McCool. I didn't have an
No,
exhibition.
in sexually dangerous. McCool is in a sexually
Psychological.
dangerous.
Well,
No,
that's,
in a sexually dangerous, that's in lieu of, that's a somewhat separate thing. I want to know, in the sexually dangerous persons context, which is a relatively new part of our jurisprudence, where we incarcerate people after they have served their criminal sentences. McCool, it's not after they have served their criminal sentences. I'm talking about after they have served their criminal sentences.
and with what regard? I'm missing the question.
In what cases have courts upheld the reincarceration of persons on grounds of dangerousness which have not found physical dangerousness?
I don't have the list of those citations.
Are there any?
I don't know.
Have you looked?
No, not on that point. What I did was I looked
Do you
at,
think you have any responsibility to see whether anybody else has taken the position?
I don't believe there's one on, well, these are case by case again. I mean, it's case by case, each person being different, each determination being different. I don't think you could ever find one that was on point for this where,
Well, in the briefs, it suggests that there are 20 states that have sexually dangerous person statutes. 16 explicitly require essentially physical dangerousness.
right.
And the others have, through interpretation, essentially required it, and Massachusetts will sort of be standing alone if it doesn't require some likely physical danger to others as a element of potentially lifetime.
But that's a decision
Incarceration.
for the legislature. That's
Well, that's, I
the
guess, our
legislature's
question.
decided to, that open and gross lewd and lascivious does warrant such commitment because the person cannot control themselves.
Do you think
So is it the danger that they will repeat, or is it that the repeating of the offenses will be dangerous?
It's that they lack control over their impulses, and therefore they are likely to reoffend.
Can I just ask you about this?
Sexually reoffend.
Can I just ask you about this? In the Supreme Court decision, it says it's dealing with that, but obviously that's with a specific statute, which you pointed out. The court talks about narrow circumstances, and then in upholding that statute, pointed out it's more than a mere predisposition to violence. Rather, it requires evidence of past sexually violent behavior and a present mental condition that creates a likelihood of such conduct in the future. Are you reading Hendricks to say that a predisposition to violence and a present mental condition that creates a likelihood of violent conduct, that Hendricks is not limited to that?
I'm saying Kendricks dealt with a statute that had that as a part of it. They didn't review a statute that didn't have, as ours stands, didn't have a requirement of physical violence. They looked at one that had physical violence, so they're noting in their decision that if you have a statute with physical violence, so these are what to look at. We have one without it. They weren't reviewing one without it. They were just commenting on the one before them.
But
So
they
I
were-
don't read
but they were
Hendricks as
talking-
requiring physical.
But they
But
also
they were talking
talk
about the power of the state in this narrow window the power of the state in this narrow window. And what's the window?
But it
Look
doesn't-
at Kennedy in concurrence.
But it
The
doesn't
power
say
of
that it
the
has to be
state
violent, physical
The power
violence.
of the state to confine persons who by reason of mental disease or mental abnormality constitute real, continuing, and serious danger to society is established.
Danger, but danger not limited to physical danger. There is still, if you look at McCool, it
But it has
talks
to be
about...
serious danger. So how do we decide whether there's
McCool,
serious but not physical?
Ms. Burbine, I would urge you not to always go back to McCool because we are dealing here with indefinite, involuntary confinement when a sentence has been served. That is not McCool.
But I would ask you to look at McCool in terms of its recognition that the sexual injury to victims is not limited to physical.
Yeah, we could look at tort law as well, but it's not an appropriate, at least in my judgment, it's not an appropriate analogy because it's a very different context. I mean, McCool is looking at something quite different.
Now, if we were to look at, looking at our statute, if Mr. Grant had been, again, sought to be found SDP, which I guess you've tried to, it would be under Section 3, which would require that he be previously adjudicated as a sexually dangerous person, which he was, and whose misconduct in sexual matters indicates a general lack of power to control his sexual impulses, as evidenced by repetitive or compulsive sexual misconduct, which you'd have there, by either violence against any victim or aggression against any victim under the age of 16, which, as far as I can tell, you wouldn't have. So
Well, we would
the
have
legislature appears to
aggression.
require violence against any victim or aggression against any victim under the age of 16 in order to hold somebody again, but you're saying it doesn't require that to
I'm
hold
saying
somebody
we would have aggression with Mr. Grant because he approached young girls in the public library and exposed himself and masturbated in front of them, so that would be aggression under...
But I don't think anybody suggested that he was prone to focusing only on
Yes, they did.
pre-adolescence.
Yes, they did. They said his main targets were adolescent girls on the younger side, that he had exposed himself to 12-year-old, a 13-year-old, two 15-year-olds in the library. And that was his primary target. So that would be aggression.
Okay, so you're saying there would have to be a finding that he was predisposed to be focusing on children under the age of 16.
If aggression, I mean, I think that fits.
So if
so
it was
we would be
merely
able
against
to.
adults, your case would fail.
Violence, if we had,
But
if
you
we
don't have
required to
violence, do you?
But I think you can't ignore that. In 2004, the legislature added the offense of open and gross to the statute,
Right, but
which meant
it also added lewd, wanton, and lascivious persons in speech may be punished. So
the legislature obviously doesn't view the requirement to be physical injury, solely physical injury. They view it as including
So
emotional.
nuisance is enough.
I'm sorry?
Nuisance is enough?
I don't know what you're referring to.
I'm just
sorry.
saying, there's the contrast between a danger to the physical health and safety of people versus conduct which is a nuisance.
I don't think
offensive.
anyone's saying you have to be found to pose a danger of reoffending, and then the crimes, are then what the legislature decided were dangerous crimes.
So you don't need an independent factual finding of dangerousness.
No, you will. It's very difficult. It's inherent in it because the likelihood to reoffend, they have to, look at whether he can be treated, look at whether he can.
We understand the likelihood, but you don't. But it doesn't have to be dangerous. It's just whether they.
It doesn't have to be physically dangerous.
No, dangerous.
No, it does not have to be physically. I mean, the judge not only adds dangerousness, but he adds physical dangerousness, and that's improper.
Do you know if in the Diagnostic and Statistical Manual personality disorders are considered more serious than mental abnormalities?
I do not know that.
Do you know whether schizophrenia or paranoia are considered personality disorders or mental abnormalities?
I do not. I do recall that one of the experts, when she talked about the defendant and his personality disorder, she said, I'm trying to remember what
It's
she
not
said.
a
She
serious-
said something. No, she said there was a disregard for the safety of himself and others. I believe that was part of her definition from the DSM of a personality disorder. So
Thank
may be
you, Ms.
inherent in
Corman.
the
Before you sit down, just
Yes.
a couple of comments. You've signed a 16K certification, which says you've complied with Rule 16K. There are no statutes attached to your brief, as 16K requires, and counsel, you didn't even file a certification, let alone any of the statutes that you cite. So let me just remind people, please do this.
I apologize, Your Honor, there was one on the back of mine, so that, this is, it's the very last page, 123A, Section 1.
Thank you. Thank you, Ms. Berlin. We'll take a short break.
All rise.